George Olola. I'm the chairman of Residents Association, Runway View Residents Association in Miango. On behalf of 500 members and others who are the owners of land currently being affected for demolition, we have filed a case through our council, Danson Omari, in order for us to know the truth, because this is not the first time we are facing controversy over the plot. So we took a step of searching for the rightful owners, and before the rightful owner made agreement with us on how to, final agreement on us, with us on how to regularize our plots, judgment was issued giving the estate of Kirima as the rightful owners. We accepted the judgment as it was and took a step of trying to resolve the matter amicably with the estate of the late Kirima. Only later on to learn that the person who had been brought to us as the rightful owner has come up. That is the family of the estate, the estate of the late Dominico has shown up and is showing documents which seem to be making sense, seem to be the correct documents. So as the residents who have invested massively in the area, we were left confused. And as at now, we don't know even if the government comes up to resolve the matter on our behalf with whoever is the rightful owner. We are still very cautious because we may pay any of the claimant as the rightful owner later on to be told that that was not the owner. So our plea and our request is that first and foremost, we would want this matter to be resolved as fast as possible, because some of our members are even right now admitted in the hospital. Some are in very critical condition because of stress and pressure. These people are completely confused.
We moved courts last week on Friday, asking the courts that the residents of the subject land be enjoined as part of the proceedings, although the judgment had already been entered, with a view to have the same judgment set aside, owing to the effect of public interest that the judgment has upon all the residents that are ordinarily residing in that property. Now, the chairman of the area approached our law firm, representing over 500 residents who have been ordinarily living there and who are likely to be affected by the demolition if the judgment of the court is executed. Not only are there residents who will be affected, but also we have to look at the social and economic effect of the demolition that is to be effected. Within that community, there are more than 10 schools, more than 10 designated areas of worship, including churches and mosques, and very many health facilities that people have been relying on for the longest period of time. And because of the issue of ownership, which had not yet been settled, the residents of that area were not sure how to regularize their stay. And therefore, we are asking the courts to enjoin us in these proceedings, because when we look at the documents that we have, there is nowhere that the Kirimas appear in any of the documents from dating back to 1905, when the lease that was initially granted to Domenico Di Masi was issued on the 27th day of October 1905. After that, and it was issued by the then acting commissioner for the East African Protectorate. After that, it was issued in the it was registered in the Nairobi Registry of Deeds by James Roberts, 339 of 1905, and the lease was was effected to James Thomas and William Henry for 99 years, where they used to pay a yearly rent of 313 cents rupees. Then there was the assignment, which was dated the 26th day of June, 1911, and a conveyance to that effect dated the 4th March of 1913 that registered both James Thomas and Charles MacDonald, and the subject land was about 4025.41 acres, assigned then to Charles MacDonald Reginald and Julian Jamison as tenants in common, where the rent they were paying was 251 cents rupees. Now, after that, the land then moved by way of assignment, dated the 16th of April 1917, with George William as the new person taking over the land. Thereafter, there was an assignment dated the 1st of December 1930 to George William and one individual known as Muthura. And when the Muthura died in 14th March 1944 interstate, the letters of administration were issued to one Satpal and Deraj Sharma on the 21st of April 1944 by then the Magistrates Supreme Court of Kenya in Probate and Administration number 63 of 1944. Thereafter, the subject land was assigned on the 1st of June 1950 by the Supreme Court of Kenya through a grant dated the 21st April 1994. Now, in that assignment, the sale agreement, the person paid 90,000 shillings for the purchase, and the land was then divided and alienated and described as Plan Number 347, where he was supposed to pay a yearly rate of 62 cents. And this was signed and sealed by the persons who were, by the parties of that assignment. And part of the annexures that we are adducing before court is the Colony of the Protectorate of Kenya map, land reference 507, which shows the physical map and signed mutations. So the estate then went over to succession in cause number 625 of 2009, and a grant was effectively issued on the 29th day of August 2023, and the beneficiaries of that property included Bernardo Demasi, Moses Ngugi, Antonio Kenyatta Demasi, Jospena Demasi, Elizabetta Demasi, Elena Demasi, Bernardo Demasi, and Nicholas Demasi. So from that whole prose of how events followed on how that land devolved, there is nowhere that shows the Kirimas had any interest in that purported land. And therefore we are inviting the courts of law to do justice, especially in light of the public interest that is likely to affect all the residents that have been residing there, and the effect on that, on what that will do on the citizens who are ordinarily hustlers within the Republic of Kenya.
So the questions that arise, were the proper parties before Justice Okongo in Kisumu? The parties that were litigating in Kisumu were pretenders to be the owners of the land. The Kirimas pretended that land was theirs. The people who sued pretended to be the owners of the land. And that is why the judge left with any document granted Kirima those orders. We have now filed all these documents to the attention of the judge to review that decision. We have equally written a letter to the Director of Criminal Investigation to investigate the documents the Kirima presented before the judge, to investigate the document the Dominican guy has presented with a view of establishing which are the lawful, rightful documents of ownership. If any criminal act was done, then the DCI and the DPP will take action. We have equally written to the National Land Commission to investigate the titles of this land. How did this land move into the alleged Kirima family? So we have presented documents. For those ones who have seen the judgment that was issued in Kisumu, no document was produced. The Dominican guy has the document, the original document. So we have moved to get stay of execution of those orders, because under the law, it is very clear that once discovery of materials that were not available at the time a judgment was entered or at the time the case was heard, the court is bound to review its own decision based on the new materials that we have presented before the court, which was not present at that time. The matter has been certified, and we are appearing before the judge on the 20th of this month, which is earlier than the date of eviction. The questions the owners of the property are asking, who do they deal with as the rightful owner of the land? Is it Dominico? That is why we have presented this document to government agencies to certify if the documents that we have presented are genuine, and which we are sure are genuine, then the orders granted be vacated. Very fundamental conveyancing questions. Where is the stamp duty paid by Kirima? Where is the sale agreement? Between who and who? Where is the grant that allowed the one who sold them pay? Where are the conveyancing documents that they have? Lastly, which bank account did they put the money? There is no land unless it's a gift to a son or to a wife. Where is the account they deposited money to Dominico to say they had a legitimate expectation that after paying consideration, then they have the land? So we shall stand firm with over the 500 people who have an equivalent of 5,000 family members who are likely to be evicted. And we'll be calling upon all government agencies, including the minister, the cabinet secretary for lands, who is the custodian of documents called land, to come out, plus the peers, and explain where did the government go wrong. And now that we have brought to the right information, we believe very strongly that that judgment will be set aside. The people of Mihango, the people of the purportedly called Kirima, because with this document, there's nothing called the Kirima estate. You can only have an estate if you are a son, or you are a daughter, or you are a beneficiary known by law of the deceased person. That is the only time you can be a party to a succession, to a matter called the estate of somebody. Let us not create a GAZA strip in this country by ignoring our own Kenyans, and we focus more on those ones outside this country.